Generally speaking, parents are responsible for the civil misconduct of their children. The only caveat to that statement has to do with the amount that they are responsible for. Some states, like California, have a maximum amount that the parents can be responsible for with respect to the misconduct of their children. So you want to make sure, of course, that your children are insured with respect to if they're driving, because if they're driving your car and if they don't have a license, then the odds are that they don't have insurance. You don't have insurance. But let's say hypothetically that your children have friends over and they're horsing around as a result of wrestling on the floor or something like that. Someone's arm is broken. Your typical homeowner's policy is going to cover that up to the maximum amount that parents are responsible in your particular state. The other important distinction is between a negligent act and an intentional act. So if your child intentionally hurts someone, then generally speaking, insurance does not cover intentional torts, intentional bad acts. But if a child does something that might be illegal, but doesn't do it necessarily intentionally, but does it negligently, then there might be coverage. An example would be driving under the influence of alcohol and having an accident. Now, it's illegal to drive under the influence of alcohol, but generally speaking, if it's the first time and they have an accident and their blood alcohol level was not horrific, they probably were driving negligently, didn't realize that they were impaired, and caused an injury. In that case, usually insurance is going to cover it. However, if the child has a history of abusing alcohol, and if the parents were aware of it or should have been aware of it, and then the child gets behind the wheel and has an accident and seriously or kills someone, there is a case where the insurance company might try to indicate that the parents were on notice that this was a problem, and that by not doing something about it with respect to intervention, that it then changed from negligence to an intentional tort in terms of the level of duty of care that was owed. And that's a situation where hypothetically there may not be insurance. But insurance companies have to be careful when they deny coverage, because if in fact they should have provided coverage, if it's later determined that, and if they initially didn't, then the insurance company, might be liable for what's referred to as insurance bad faith, in which case not only do they have to pay the damages, but then they're responsible for paying the pain and suffering, not only with respect to their insured, but also with respect to the third party that they denied coverage in terms of paying damages. So insurance companies have to be careful about that. As a general rule, the law will try to find coverage. That's the general rule. Obviously, the facts of each individual case will determine whether or not, in fact, there's coverage for the tort that happened on that particular occasion.